legacy of our beloved former dean at Osgoode, Peter Hogg. My name is Mary Condon. I'm also one of that group of former deans, and there are a couple of others of them here in the audience. I'm delighted to be here, and I'm very thankful for the opportunity to chair this wonderful panel this morning. I do want to start with a number of thank yous. First of all, special thanks to the co-chairs of the conference, Jamie Cameron, Sonia Lawrence, and Patrick Monaghan, for putting together such a wonderful program for us today and inviting such special speakers to participate in a variety of sessions. I'm especially thankful to the co-chairs for keeping the momentum of their activities going in the transition from myself as the dean to the current dean, Trevor Farrow. I also want to say my personal thanks to all of those who helped behind the scenes, Anita Herman, the Director of External Relations, and her team, and especially Erica Robinson, who's also been mentioned earlier this morning. Of course, in advance, I will thank all of the speakers on our panel this morning who are either former students of Professor Hogg or colleagues of Professor Hogg, but in all cases are distinguished lawyers and legal academics. I was told that I should be very limited in my discussion of their biographies in order to keep to time. So I will refer you to the conference website for a fuller account of all of the distinguished achievements of our speakers this morning. But I will just mention that, of course, Professor Richard Haigh and Professor Sonia Lawrence are both current faculty members at Osgoode Hall Law School. Cara Zwibel is currently the Information and Privacy Commissioner of Ontario and previously the Director of the Fundamental Freedoms Programs at CCLA. And Ravi Amarnath is a member of the Constitutional Law Branch at the Ministry of the Attorney General. And in discussions with the panel members before this morning, we decided that, of course, we all have a very different angle, or they all have a very different angle to take on questions of Peter's legacy as a teacher or a mentor or a colleague, but that we would think in particular about the legacy that Peter leaves for those of us who are continuing to be colleagues as we move forward as teachers and mentors. But before I introduce our first speaker, since it's a bit of a theme to engage in some personal reminiscences about Peter, I hope I can use my spot as chair of this panel to just say a couple of words about that. There are many things that could be said, and some of the same experiences that Justice Macpherson mentioned about the things that he learned from Peter as a young colleague. I certainly also experienced in my own time as a new colleague at Osgoode the advice and warmth that Peter showed me. He invited me with Fran to the opera. We went to picnics and to his house and so on. But there are two anecdotes that I might just share. The first is very quick, but just to say that when Peter was dean, I had the opportunity to be the chair of the Faculty Recruitment Committee, and this was the time that deans of Canadian law schools went to the elite Ivy League programs in the US to meet the Canadian graduate students. And so I had a wonderful road trip with Peter in that capacity. We went to Harvard and had a lovely visit and a lovely picnic with the Canadian graduate students studying at Harvard at that time. And the reason why it's, I think, useful to mention that is that one of the Canadian graduate students that we met on that visit was Trevor Farrow, now, of course, the Dean of Osgoode Hall Law School. So it's a wonderful opportunity to see that that line emanating from Peter's time as Dean and now to Trevor. But the other anecdote, and I realized as I was coming down to this session this morning that this anecdote may say more about me than it says about Peter, so it may not be the most wise anecdote to relate. But in 2001, when Peter was the dean, it was decided for the first time that Osgoode faculty should receive merit pay for their activities as teachers and colleagues and scholars. And a committee was set up to determine who would receive retroactive merit pay for 15 years. And on that committee was Peter as the dean, and Neil Brooks and myself. But the challenge for me was that at the time that we were going to be looking at everybody's files to determine who should receive and how much merit pay people should receive, I was just about to go on parental leave with my first child. So Peter decided that in order to make this experience of allocating merit pay easy for me, he and Neil should come to my apartment, which, indeed was convenient at one level, but, 4 weeks into having my first child, I would say that my apartment or my household in general was fairly chaotic and full of confusion and very emotional experiences. Anyway, the other complication for me was that my mother, some of you know that I'm from Ireland, my mother had come over from Ireland at this precise time to help me with this new baby. So I thought, well, my two senior colleagues were coming, so I should just banish her and the baby to a back bedroom of this apartment, so that we could have this, very professional meeting in the living room. Of course, my mother would have no truck with that. And so in the middle of the meeting, she shows up with the baby in tow because she assumes that my senior colleagues will want to admire this beautiful baby, which they do in a very gracious and a very warm way. Peter just really rose to the occasion. He praised the baby, he congratulated me, he chatted to my mother. And it was really a lovely experience and really, one of those standout moments that really illustrates Peter's capacity to be just a warm human being, someone who is really was very willing to see all of his colleagues in the fullness of their lives, both personal and professional. So with that, I'm going to now turn the floor over to our first speaker, Professor Richard Haigh, and what you will see is a great deal of continuity with some of the points that have been made earlier today about Peter's wonderful achievements as a teacher, although Richard has taken those anecdotes to the next level and actually engaged in some very interesting quantitative assessment of the evidence about Peter as a teacher. So please come forward, Richard. Thank you.
That's not going to work. Thank you, Mary. And it is a privilege and an honor to be speaking at this conference. So let me just make sure I know how to do this. This is forward.
It just froze.
You can also
There
just
you go.
Okay.
It just froze for a second.
Okay, thank you. So yes, as Mary said, I'm going to carry on largely from what Patrick said earlier and in using some of the data that he talked about. So I know some of you may know Peter as a teacher. You were fortunate enough to have him as a professor at law school, or like me, I didn't go to Osgoode, but I had him as a mentor when I first came to Osgoode. So I know about his teaching from that perspective. Some of you may also know about him because of his scholarship. Probably many more of you know him because of his scholarship. The books, the articles, the conference presentations, the citation record, et cetera, et cetera, et cetera. The list is pretty endless with Peter on that. What I'm going to try and do is give a little bit of both his teaching and his scholarship through a method that I learned from him as well. And that method comes from the dialogue article. Peter, in that article, at least from my perspective, I learned the idea that you can do very basic but very effective legal research by kind of empirical analysis. So that Hogg and Bushell, now Thornton article, the charter dialogue between courts and legislatures, or perhaps the charter isn't such a bad thing after all, is my starting off point for for what I did in this little presentation. By the way, I learned from that article that you can use a contraction, because in that title, perhaps the charter isn't such a bad thing. Only Peter would have, I had many professors before that saying, never ever use contractions. So I learned another thing from Peter on that. So for this presentation, I decided to do some basic research of my own. What I did is I examined Peter's teaching evaluations at Osgoode and his track record of citations at the Supreme Court of Canada. Hopefully you'll have a sense, following on from Patrick, of how incredibly influential Peter was. And as my colleague Neil Brooks said at Peter's retirement talk, he was the Gretzky of legal academics. We have Joe DiMaggio, and now we have Gretzky. And I'll add in the Socrates of law teachers. Only Peter was much nicer. Before I even get into that, I should thank my researchers for the work they did in helping me with this. Alyssa Music, who is a 1L student of mine right now, spent a number of hours in the rare book room at Osgoode going over all of the evaluations for his 30+ year teaching career. My York colleague, Thaddeus Huang, who loves statistics and empirical analysis, ran some analyses on Lexis quick law data to get the citations at the Supreme Court. And I also, as mentioned, want to thank Neil Brooks, because he provided me with his retirement presentation paper, which helped me again in structuring this talk. So starting off with the teaching. Peter taught at Osgoode from 1970 to 2002. There were some sabbatical years, so effectively about 30 years of teaching. There are 58 course evaluations for Peter in the Osgoode archives, over 3,600 student responses on record, which alone is remarkable. That's about 70% response rate for students who had Peter as a professor. And just to give you a sense of, prior to 1990, evaluations were only numeric at Osgoode. So after that, evaluations came in two parts: a list of questions requiring a numerical score, usually between 1 and 5, and a more open-ended component where students could write or not write as they wished. Qualitatively then, after looking through these, it's a mathematical fact, as we've already heard, that in every year he was evaluated, students scored him highest of all Osgoode professors. Qualitatively, it's fair to say no one had better written remarks than Peter over the years. So this is, we're starting with the latter. I know it's a little hard to read, but this is why I love archival research. Look at the photos, forget the comments for a second, but just look at that. They're handwritten. It's like going back 20 years when I used to grade handwritten exams. Cursive writing, look at that, that's just great. Anyway, here's what you typically get when you see Peter's evaluations. Look at that top one, my hero. What other professor in Canada is an actual hero to students? I cannot imagine any. I asked ChatGPT and it drew a blank, so. Or take a look at the second one. It's Hogg. What else needs to be said? I could take that advice. I could put up these slides and walk away and just let Hogg speak for himself. But unfortunately, you do have to listen to more of me on that, because there is so much more. There's the comment I could not put up because it's too raw. I taught trusts when Peter also taught trusts. And there was a comment on one evaluation that said, I wanted to take this course with Dean Hogg and thought that trusts would not be as interesting with any other professor. That stings a little bit. They don't even know me. How? Comments about Peter regularly seem to measure the rest of us against his impossible reach. Like these ones, quote, the best instructor I've ever had. It's a shame all instructors and courses can't be like this one. Hogg should teach a course to other professors on how to be a law school instructor, close quote. What that student didn't know or couldn't know is that it's almost certain that you cannot teach what Peter did. Or, well, actually, no, on second thoughts, Peter probably could teach the unteachable, but nobody else could. Next are the more quantitative evaluations, sorry. I assume most of you know the kinds of things that are asked at university evaluations of professors. As mentioned, Osgoode uses a 5-point scale. Here are some of the types of questions that are asked on those evaluations. You can read them at your leisure. So what we've done though is comparing Peter to other constitutional law profs at Osgoode. Unfortunately, I'm not included in that group because this is the time period 1972 to 1995, and that was before my time. All of us teaching now are lucky, right? So 92% of his students rated him as very effective. The other profs, these are other constitutional profs, 60% lower at 35% effectiveness. Or to scan the figures in a slightly different way, almost 1/3 of students thought that the other con law profs were not all that effective. Basically, nobody said that about Peter. An entertaining way to contemplate this, which isn't entirely accurate based on the question, but I thought it would be fun anyway, is to say that for every 10 words said by Peter, students comprehended 9 of them. For others, 3.5 words out of 10. We've had other data we've collected other data comparing Peter to other constitutional colleagues, but and that will be in the paper to follow. And what we also did is compare Peter to other law profs at Osgoode teaching a variety of other subjects, so non-constitutional law. But the numbers are pretty much similar. In fact, if I was to curve all of my colleagues, as we do for students, most of us are in the B to B plus range. Peter is at the top of the class every single time. You think about that, in over 30 years of teaching, over 3,600 evaluations, he is number 1. It's incredible. Moving on to Peter as a scholar. This is where Neil Brooks compared him to Gretzky, so I decided to go with that. I asked ChatGPT who is considered the best professor ever. Of course, I know Peter is good, but I didn't expect him to make the list. ChatGPT did not give me Socrates, but it gave me the following: Albert Einstein, Marie Curie, Stephen Hawking, Richard Feynman, and Noam Chomsky. Heavy on the science. Chomsky is a bit of a surprise there. But then I asked ChatGPT for the best Canadian law professors. Peter Hogg topped the list, ahead of Beverly McLaughlin, and then Ronald Dworkin, which is a surprise as well, because Dworkin, as ChatGPT says, is not Canadian, but apparently he has had influence over Canadian academics. Anyway, Peter is at the very top of the ChatGPT list. As a legal scholar, one of the ways to simply measure someone's work, especially when it comes to criminal and constitutional law, is the influence a person has had at the Supreme Court of Canada. As Neil Brooks noted in his retirement speech, Peter Hogg seems to have inserted himself, almost assuredly unwittingly, into the role of the 10th Justice of the Court. Thaddeus, and my research, places him at the top of the citation tree by a huge margin, that he is, as Brooks implied, better in law than Gretzky was in hockey. So here we'll see some of the data. Again, this is really small, but Thaddeus, as my research, tells us that there are 253 Supreme Court of Canada cases in which Peter Hogg is cited. Sometimes he's cited more than once in a case. Sometimes that means by different judges, or sometimes it means that it's different works of Peter's cited. So that means that the total number of citations we have is 278. And if you look at the record, it's there from the beginning of his career to the end. So he's first cited in 1977. Then there's a gap year, 1978. And then every single year from 1979 to the present, at least one citation by the Supreme Court of Canada. Many years have 9 or more citations, which is about 10 to 15% of the court's docket. I dug around to see what Peter was doing in 1978, because that's the outlier year, and found nothing out of the ordinary. My tentative diagnosis for 1978 is what's commonly referred to as a sophomore jinx. Peter grabbed the attention of the court in 1977, and then they moved away from him because they thought they didn't know what, some young Turk who's written a book. So they left him alone for a year. And then when they realized what it was, they come back to him in 1979 and have stuck with him ever since. This chart shows where the citations come from. As you can see, most of the citations are from the Inimitable Constitutional Law of Canada book. It's been cited 196 times, or approximately 70% of Peter's total. But there are 18 citations to his tax book, 10 citations to the 2 dialogue articles, 26 citations to the liability of the Crown, and 29 citations to other papers. By the way, the numbers differ from Patrick's, and that's partly because when Thaddeus did this analysis, we don't double count. If there is one citation listed on a case, we just count that as one, even if the judge mentions it 4 times. For now, for this presentation, we'll clarify that in the paper. But as Patrick said, note that the tax text was meant to be a student handbook, and yet it's been cited by the Supreme Court 18 times. Almost every tax case at the court. In fact, according to Neil, the first time it was cited was not even a published book. Then the final thing we did is compared Peter's output of citations at the Supreme Court of Canada with a few contemporary, eminent, and leading other Canadian law professors. So these are all outstanding and well-known law professors, at least to those of us in the academy. We had to break this down into 4 periods because in order to get the cohorts to match up. And I should say my sample is somewhat biased, which again, we'll correct when we do more research for the paper, because they're all male. And that's partly because of the period chosen. In the interest of time, I'm just going to show the beginning period, the 1977 to 1977 to 1989 period, and the period at the end, 2010 to 2022. This slide is the first period. The only other person cited here is Harry Arthurs. You can just barely see the color coding at the top because the Zoom banner almost blocks it out. But Arthurs is in orange. He had a few citations in the 1980s. Harry's best year was 1987, where the court cited him 4 times. He even outpaced Peter that year, but that was short-lived because Peter was winding up for his all-time best year of 1989 when the second edition of textbook had clearly taken wing, and that's the really tall one on the figure on the right. Finally, the last slide shows the same group over the last 13 years. Given the fact that criminal law takes up almost 50% of the Supreme Court of Canada's docket, I decided to include 2 very different criminal law profs, Kent Roach from the University of Toronto and Peter Sankoff from the University of Alberta. Both have successfully engaged the Supreme Court of Canada. Roach in purple with 58 citations over the years. Sankoff in gray and blue, a sort of gray-blue color, with 26. But the picture, you don't really need to know. The picture tells 1,000 words. Red is predominant over all of those years. We've got many more hours to work on this quantitative analysis of citations. I'd like to compare Peter to other justices on the court, for instance. Is Peter cited more than they cite themselves? We'll also add in other academics. As I explained, I think I need to broaden the pool. Maybe even try Ronald Dworkin, compare him to Peter as well. And with that, I think I will finish, and thank you very much, and thank you. Oh, I should show you the last slide though, because it's my.
Well, thank you very much, Richard, for getting us off to a rousing start. And our next speaker is Mr. Ravi Amarnath from the Constitutional Law Branch of the Ministry of the Attorney General. Thank you so much, Ravi.
Thank you, Professor Condon. And I wanted to start by saying what an honor and privilege it is to speak at this conference, and I'm most grateful to Professor Lawrence for the invitation. So unlike some people here, I didn't have a long-standing career with Professor Hogg. I wasn't colleagues with him for year after year after year, but I did work with him for 2 years when I started my professional career at Blake Cassels in Graydon. And my talk will be much less, or really not quantitative, but we'll focus on my experience working with him from 2015 to 2017. And over this time, we published 2 pieces. One, a paper at for the U of T Law Journal, and the second, a chapter in the Oxford Handbook of the Canadian Constitution. And at the outset, I wanted to say there are 3 takeaways that I took away from my experience with Professor Hogg. Three that I aim to keep with me today. The first is that he taught me how to put together an academic paper. The second, he taught me about the importance of your audience when authoring a paper. And the third is I learned some, and specifically as it ties to this panel, I learned some important lessons about what good mentorship looks like. So like many things in life, my encounters with Professor Hogg were really the result of chance. In the spring of 2015, I was desperately searching for a job, and I was not living in Toronto at the time. And I was given the chance to, at the time, what was a very cutting edge thing, to interview with Blake's over Skype. And through that fortuitous opportunity, I secured an associate position at Blake's, starting in the fall of 2015. And after commencing my employment, an email went around to some of the younger associates seeking assistance on a paper Professor Hogg was working on for the appellate court seminar, which was to take place in January 2016, or almost 8 years ago. And while the idea of writing an academic paper always seemed very exciting to me, the execution seemed daunting. I mean, how could one come up with an idea that was original, that had enough content to survive the rigors of editing? I'll come back to this later. But I decided I wanted to try this out. So I put my name in and was fortunate to get an opportunity to work with Professor Hogg. The working title for the paper at the time was Why Judges Dissent, which was to be a review of how frequently judges dissent at provincial appellate courts across Canada. And during my first meeting with Professor Hogg, I learned a very important lesson, one that I try to carry to this day. And that's that mentorship need not be hierarchical. So rather, the role of the mentor is to guide an individual so that their talents can shine and the overall objective can be achieved. So whether it's putting together an academic paper, a legal submission, or presentation, and the final product is improved. I came into this first meeting with Professor Hogg with a lot of nerves. We've seen the stats. Everyone knows he's the most cited author in Supreme Court of Canada history, et cetera, various books. And at the time, I had a grand total of 0 academic publications to my name. So reluctantly, I had to come in with a few ideas for this paper. The presentation was quickly coming. And I shared one small idea. I said, well, what about if we discuss in the paper how dissenting judgments can impact the dynamics in a court? I mean, people still have to work with their colleagues afterwards, and practices that maybe courts implement to ensure that the collegiality of their colleagues can maintain as they continue to work together for many years. And I wasn't really sure how the idea would be received. And I'll never forget how Professor Hogg took in the idea, and a lot of people have talked about his pauses, and he paused momentarily, and he looked me in the eyes and he said, "I think that's an excellent idea." And the validation I received from him that first meeting really propelled a fruitful few months of working together, where I learned more about dissenting judgments than I could have ever imagined. So together, Professor Hogg and I explored a number of interesting topics, or at least what I thought was interesting, including the evolution of dissenting judgments and how the practice of writing judgments has evolved from the seriatim practice where judges wrote their own individual judgments to the current tradition of writing judgments. I learned about ideas we take for granted, such as the post-hearing case conference at the Supreme Court of Canada. That was only something that really started in the 1960s. And we discussed sort of the merits and drawbacks of courts writing consensus judgments as opposed to encouraging dissent or having various judgments within a set of reasons, and whether the pros and cons of each. The draft paper was received very well, highly at the seminar. However, it still wasn't quite a paper. It was a collection of interesting ideas. And for anyone, we've had some sports analogies, but to analogize to music, we had a number of interesting parts. We had lyrics, we had a backbeat, we had a bass line, but we had no song. It wasn't a paper. It was just a number of interesting ideas. We needed something a little different to make it an actual publishable paper. And this is where my trepidation came in. Maybe how are we going to do this? And this is where I sort of learned again something from Professor Hogg, which is a valuable lesson. Sometimes a small tweak can take what's a collection of ideas and make it a publishable paper. He came to my office one day and he said to me, and this time I'll spare you the accent, he said, I think instead of simply writing why judges dissent, we should write about why judges should dissent. It was a small tweak, but that little change converted what was really just a collection of ideas into a focused publishable paper. We had a song. Now, in the canon of Professor Hogg's publications, this small paper we put together is really a footnote in his long line of illustrious works. However, I was pleasantly surprised in preparing for this presentation and in putting together the more fulsome paper, which will come out later, that this paper continues to be cited both by domestic and international scholars who've published subsequent papers on the role and importance of dissenting judgments in shaping the law within Canada and abroad. My second experience with Professor Hogg came shortly after the publication on dissenting judgments. He came to my office and wondered whether I could assist in putting together a chapter for him in the Oxford Handbook of the Canadian Constitution on charter dialogue. And I was puzzled by this request. What exactly was I going to contribute to this publication? The concept of charter dialogue was long-standing and had been well canvassed in his two publications with with Alison Thornton and later with Alison Thornton and Professor Wright. But I wasn't going to turn down an opportunity to work with him, and I accepted the request. The chapter was meant to be something that was not for an audience that was not familiar with the Canadian Constitution. So the task was straightforward: summarize the features of the Constitution that facilitated dialogue, and to provide some examples of how dialogue has been applied by the court. And as Justice Monahan outlined in his presentation today, in fact, one of the examples is how it's impacted the remedies the court has issued in subsequent judgments. But I was surprised, given that this was a well-established theory, and obviously he was the one who had one of the co-authors of the theory, but he gave me the space to facilitate other ideas that we thought could make the chapter a little bit more dynamic for the reader. And through this back and forth, we used what at the time was a recent case, the Carter case, to better illustrate the concept of charter dialogue. And the chapter was sort of bookended with both aspects of the case. It began with a discussion of the case itself and what the court's order was, and it ended with sort of some of the debates in the legislature, which referenced the decision. So it sort of illustrated for the reader this idea of charter dialogue being a real thing, which continues to be present in Canadian constitutional law. And I think the use of the case helped make the chapter a little bit more dynamic for the reader. Now, Professor Hogg, when I was working with him on this paper, remained very busy when I worked with him. He continued to work on other academic pursuits. He was involved in active litigation at Blake's, and of course, he had his book to continuously update. But he always made time for my questions. He thought carefully about my ideas, and perhaps most meaningfully for me, he took time to chat about my life, my career, my family. And a lunch with Professor Hogg was always a 2 to 3 hour affair. This is something that I always feel fortunate to have had the experience of. But it really meant something for me at the time. Again, I was not a significant person at the firm. I was just another lawyer, I felt, at the firm, but it really meant something to me that he made time to remember, to ask questions about my life, projects that we worked on. And it signaled that I was more than just a transactional piece of his career. He even said he was someone I really valued as an individual. So to go back to my takeaways with him, he taught me how to put together an academic paper. And it's not as though I've gone on and done a series of academic publications, but even within my own professional writing, to Justice Laskin's famous phrase, forget the wind up, get to the pitch. As a practitioner, there's a lot of emphasis on this sort of point first, concise writing. But what I realized is it's not always possible to get there without first kind of really exploring the breadth of ideas. You have to sometimes really start here, and then only through having all the ideas you can narrow down to something hopefully for a court, which is point first and concise. So when doing sort of writing or working with colleagues now in a professional setting, it's something, I encourage them to do. Just get your ideas on paper, and then we can sort of work on all the nuance of the submission. The second, again, is about the importance of an audience in authoring a paper, and to translate that to practice, your audience when you're giving a legal submission. So even if you give the same legal point, a Section 15 submission, but you're doing it in front of the Supreme Court of Canada, in front of the Court of Appeal, in front of the Superior Court, in front of a tribunal, those are all different audiences, and it has to be presented differently to each audience. And that's something I take away and hope to share with my colleagues as I work with them today. And again, and really the most important one is I learned about what good mentorship looked like. Often, or at least when I started in the profession, there was sort of this idea of these people who are unattainable, people who you could never be like, right? These revered figures who couldn't be matched. But from my experience with Professor Hogg, who really is, we've called him, the Gretzky of law and such. What I learned from how he practiced mentorship, it's really about bringing out the best in who we work with and creating a sense of self-belief in them, that they can achieve any goal that they want to. So overall, I just want to say that I really cherish the time I had to work with Professor Hogg. I'm proud of the work we produced, and the lessons on mentorship, some of which I've shared with you today, I hope to be able to share with others as I continue my career. Thank you.
Thank you so much for those really insightful remarks about mentorship, Ravi. Very appreciative. And I should have said at the outset that we will have some time for comments and questions, I think, at the end of this panel. So if you have anything to share, please think about that. And so with that, I'll move on to our third speaker in this session, Cara Zwibel, who also is going to share some experiences of her time working as a research assistant with Professor Hogg.
And I do have some slides.
It's just the gain, I'll turn it down.
Right. Hi. So one quick housekeeping item. I am not the Information and Privacy Commissioner of Ontario. I am legal counsel in the Office of the Information and Privacy Commissioner of Ontario. I feel like my boss would probably appreciate me pointing that out. I am going to talk a little bit about, is it sounding okay for all of you? Okay. I am going to talk a little bit about some substantive law stuff, but before I get to that, I do want to talk about how I came to know, I would have referred to him as Dean Hogg, and I probably still will, because calling him Peter just feels a bit too familiar, even though I'm sure he would have been very comfortable with it. I met Professor Hogg actually before I started law school. And I had heard his name because I was a political science student in a class taught by Christopher Manfredi at McGill. And Professor Manfredi had written a responsive piece to the dialogue article. And so we talked about dialogue theory in that political science class. And I came to know who Peter Hogg was through that. And I admired his work. I'm not sure that I can say right now whether I thought that the dialogue theory was an accurate description of what was going on, but I know that I found it sort of maybe an appealing ideal to aspire to. And when I was considering where to go to law school, I recall this day very clearly. I wanted to return to Toronto. And so I went to both of at the time, the two law schools in Toronto to check them out. I was fortunate enough to have an opportunity to go to either one. And my experience at the other law school was that I sat in a room with a professor who basically was asking, what was the question, right? Why did I need to check out the schools? It probably should have been obvious that I would go to that school. And he made a point of telling me that I did not have the highest GPA of all of the political science students from McGill that they had accepted that year. So I should, I think, have considered myself fortunate to have been accepted. Now, this was, at a beautiful downtown campus. And then later that day, I went, no subway at this time, drove up to Keele and Finch and, I got it into a building with very, very few windows and met a very lovely woman in the admissions office who showed me around the law school. And as we were walking around, Dean Hogg was in the hallway and she stopped him and introduced him to me, and he shook my hand and she said, Cara's thinking of coming to law school here. And he said, I hope you'll join us. I hope we'll see you next year. And, there was a picture earlier today of Taylor Swift. It was a little bit like that kind of moment where I felt a bit starstruck. So needless to say, I did decide to attend Osgoode and feel very lucky that I made that decision and was even more fortunate to get the opportunity to work as Professor Hogg's, Dean Hogg's research assistant the summer of my first year. And that was a job that I had during the summer and then sort of continued off and on during the academic year that followed, and a bit more also in my final year at law school. And I remember that summer because I spent a lot of time in the library at Osgoode with other law school colleagues who were also working for professors. And I remember many of them had sort of fleeting interactions with the professor that they were working with. And Dean Hogg, by contrast, despite being the dean of the law school and an extremely busy and important person to the institution, made a point of having basically a weekly lunch with me. And it wasn't a working lunch. We would talk about the work and then we would go have lunch. And we would talk about our lives. He would tell me about his children, talk about careers. And I think that the thing that, like Ravi has talked about, sort of the thing that stuck with him really was the fact that despite the fact that I saw him as really this celebrity figure, he treated me like a colleague. And that's something that I've always tried to do with students that I've worked with as a lawyer, is to treat them like a colleague. And probably the greatest compliment I ever got was from one student who in a thank you note to me said, I appreciate that you always treated me like a colleague instead of a junior. So one of the things that I was fortunate to get to do during that time, and it wasn't during that first summer, but later on, was to co-author a piece with Professor Hogg. And I will say that it's possible this has maybe contributed to the imposter syndrome that I generally feel, because I always wonder whether being attached to that name has helped to push me in a number of different directions and helped me achieve some of the things I was fortunate to achieve, like getting a clerkship at the Supreme Court. I always wondered if that letter from Professor Hogg was really kind of the thing that that pushed me through the door. But he was so kind and generous to make this offer that we co-author this piece, because really I had done a lot of research for this this piece. It was something he was asked to write, actually in honor of for a conference in honor of another academic, a conference in honor of John Willis, and I, I had done some research on the concept of the rule of law and looked at how the courts were using that concept, but I really didn't, and still frankly don't feel that I earned that co-author credit. But Dean Hogg did feel that way, and I'm really grateful, because not only did we get a chance to work on the paper together, when it was presented at the conference, he invited me to come and present it with him. And when I clerked at the court shortly after that, it actually ended up getting cited in a case that I had nothing to do with. Which was really, I think, when it sort of struck home that this was probably going to be something that would be very impactful for me and sort of stand out throughout my career. So I'm going to talk a little bit about that paper, and it was looking at the rule of law and how that concept was used in the Supreme Court of Canada. And like I said, it was in honor of John Willis, and it was written around 2005, or it was published in 2005. And really, we were looking at, it was largely sort of a descriptive piece about how the court used that concept. And some of the cases that we looked at are on the slide. And by and large, we sort of concluded that in most of the cases where the rule of law was being used, it was a helpful concept, but not a necessary one to the decision. It supported the interpretation of textual provisions, and we characterized it as a constitutional value. The one sort of exception to the rule was that the rule of law did seem to have sort of greater normative force when it was used in cases that were largely about protecting the power and privileges of the judiciary. So in cases like the provincial judges reference and Macon, the rule of law seemed to be doing a little bit more work than it did in other cases. And this was also, I think, sort of fed in well to the paper, because it was about John Willis, who was sort of skeptical of and concerned about judges giving themselves sort of more powers and perks. So what I've done and what I plan to do for this paper, for the publication that's coming up, is to try and update this article a little bit and take a look at how the court has continued to use the rule of law. They have cited the article in some cases, and I'll look at those, but and the first case that they cited it in, the one that I mentioned that came out just shortly after I left the court, is the Imperial Tobacco case, which had to do with a scheme that the province of British Columbia had developed to basically recover costs from tobacco companies for the healthcare expenditures associated with all of the illnesses caused by smoking. And in that case, Justice Major, who wrote the decision for the court, pretty firmly and explicitly rejected the notion that the rule of law could be an independent basis for striking down legislation. And I think, commented on some of the things that we had talked about in the article, that you could kind of give the rule of law almost any meaning you wanted it to have. There was lots of, it could serve as a bit of an empty vessel with which to fill whatever suited your purpose. So that that article, I think, did serve to support the thesis largely that we had put forward. Several years later, the court again took a look at the rule of law, this time in the BC Trial Lawyers Association case, which had to do with whether hearing fees were unconstitutional. And I think, again, sort of in line with the concern expressed in our piece about using the concept in a way that sort of enlarged the role of the courts and judges. There, the rule of law played a significant role in saying that hearing fees could essentially block access to the courts and served as a basis for striking down those hearing fees. I've also been looking at some other cases where the rule of law is used in different ways. In the Vavilov case, there's some discussion about the rule of law with the concurring decision being quite critical of the way the majority uses that concept, noting that it's a very sort of court-centric approach to the rule of law. And the majority in Vavilov does sort of, sorry, I'm behind on my slides, use the rule of law as a means of sort of scoping instances where correction review is warranted as opposed to reasonableness review. Similarly, in the case that was mentioned earlier this morning, the Attorney General versus G, which has to do with constitutional remedies, there's also a discussion in there about the rule of law and its use in suspending declarations of invalidity, which is something we had looked at in the earlier piece in the Manitoba language reference case. That was a case where the rule of law, again, played a supporting role, but was very important because had the decision taken immediate effect, there would have been no laws in Manitoba. And finally, most recently, there's a reference to Quebec Civil Code case where again, this is where you start to see some disagreement. And I think this is maybe a development that either hadn't sort of crystallized at the point that we were writing or has been enhanced in more recent years. But there's disagreement amongst members of the court about both the role and the meaning of the rule of law in deciding what constitutes core jurisdiction of a Section 96 court. And then finally, in the City of Toronto case, which dealt with changes to Toronto's the size of Toronto City Council midway through a municipal election, there's a very interesting dialogue between the majority and dissent about the role of unwritten constitutional principles more generally, rule of law included. And in that case, the unwritten constitutional principle that was at issue was the principle of democracy, another one that could potentially be a bit of an empty vessel with which to fill whatever might suit the purpose. And in that case, there's strong disagreement about whether unwritten constitutional principles in and of themselves can be used to strike down legislation. The dissent in that case takes the view that unwritten constitutional principles assist in developing the evolutionary understanding of rights or help the living tree to grow. The majority disagrees strongly. So I'm going to be working on this. I certainly welcome thoughts from anyone about this paper. And I guess maybe I'll conclude with just one other anecdote about Dean Hogg. And I said that, there's this imposter syndrome, perhaps, wondering whether having his sort of stamp of approval, and I don't doubt that it did a lot for my career and my future. But I remember being at the court, and if you've clerked, you might know that clerks review applications for future clerks. And I reviewed some applications. One of them was a professor we'll hear from later, Wade Wright, who's taken over the writing of Constitutional Law of Canada, and who had also worked with Peter Hogg. And I hope he won't mind me saying this, but he had a letter from Professor Hogg that was so outstanding, and it made me want to see mine. And at the court, you can ask for your file, and I did, and that was a mistake because he had very nice things to say, but it did not compare to the what he had written about this student who, he said, and I hope he won't mind, because if someone said this about me, I think I'd want it repeated, said, in 30 years of teaching, have never met a more outstanding student. So a bit of a blow to my ego, but also made me feel like, okay, he had nice things to say, but he didn't overdo it, and I still made it here. So I really have fond memories of Peter, and I'm so grateful for everything that I learned from him, and do try to emulate his warm and generous approach to mentoring and teaching. Thank you.
Well, thank you so much for those remarks, Cara. And again, I'll apologize for mistakenly elevating your role. I'm sure, given your Osgoode background and your mentorship by Dean Hogg, it will only be a matter of time before you, in fact, are the Information and Privacy Commissioner, if that's what you choose to do. With that, I'll turn to our final distinguished speaker, Professor Sonia Lawrence, of course, one of the co-chairs of this entire conference as well, but in the midst of doing that co-chairing, also managed to prepare some remarks about Peter's interest in and contributions to teaching. So thank you so much, Professor Lawrence.
I think I managed to misplace my slides, which I, of course, sent after midnight last night, and were mainly 2 photographs, because I just wanted to have photographs of Peter. So it's not really a tragedy if they're not there, so please don't worry about it. Don't worry about it. And if you think they're there, we can get them up, but if you think they're not there, okay. So, I think of myself as a person who's really a rule follower and deferential to both authority and elders, and nothing challenges that self-view more than being part of the academy and the legal profession, because deference is just so built in these spaces that it's difficult, I think, to listen to the way that we talk about people and imagine that they're real. And I guess, so I have two anecdotes that I'm going to share with you. The first one is definitely not about me, and the second one is definitely really about me. The first one is when I was clerking, I went into my judge. I had never been taught by Professor Hogg, but obviously I'd read his book because it was the only way that I understood constitutional law. And I went into my judge with some memo that I had written that was probably absurd. And she asked me a question about it, and I said, well, Peter Hogg, and she just cut me right off and just leaned in and said, Peter Hogg is not on the Supreme Court of Canada. I was like, okay, I appreciate that. We've talked about how Peter was always very clear. That's clarity too. So that was a good moment. At that point, I still hadn't met him. Then the first time I met him was actually at my job talk, during which he fell asleep. So that is the second anecdote. That one's definitely about me. He was extremely nice and, a wonderful first dean to have as a junior academic. I do think that some of these reflections on what mentorship meant to a person like Peter and the way that he was able to put time into it feel particularly difficult right now when nobody seems to have time for anything, least of all me. And having benefited from some really good mentorship and some, I guess, not very good mentorship, I really think about the loss, that the way that the profession has changed, and the fact that people really do not have time to do this anymore until they're very, very senior. And I think we're losing something. I think, Cara's career, but she's one of my iridescent bubbles. I think I was a teacher of hers as well. And her career at the CCLA and the kinds of things that she's been able to do, these are really important things that get supported through mentorship. And I do admit that I'm worried about the way that those things are going. So, okay, so let me get to my paper. Is it there, do you think? Okay, so one of the pieces of advice that junior legal academics are given, if my experience is relevant, and mostly I didn't know enough to pay attention to the advice that I was given, and one of the pieces was, do not get involved in curriculum reform. And the reasons for this are a bit more apparent to me now. More than 20 years ago, I just blithely and foolishly, ignored that advice. Thank you. Okay, so it's more clear to me now how horribly difficult any significant reform to legal education is, and the good as well as bad reasons that this is the case. When the idea of this conference was taking shape, more than one senior colleague of mine noted that Peter had been one of those junior academics who could not resist the siren call of curricular change, or was drafted into chairing a committee that he had no interest in chairing because he was very junior. So he chaired Osgoode's long-range academic planning committee, which started up in 1972 and reported in 1974. And so in the paper that I'm discussing, I'm working to explore the work of this committee kind of in a twofold way. And the first is really just a way of looking at.
Should I try this way?
Yeah, thank you. There's really only two. Is that not working? Sorry. Like I said, it's really just pictures. So the first one is a way of looking at Peter's career and its important aspects, because I think this hasn't really been mentioned, right? This, thank you so much. This committee chairship was very early in his career, long before he was dean and before he became the quietest rock star in Canadian legal history, and certainly before he became the sainted figure that he is now. And the way that it fulfilled its mandate and the kinds of things that it was exploring could tell us something about the man who was the chair. Of course, in the room is also the dean who made him the chair, so it probably tells us at least as much about Harry Arthurs as it does about Peter Hogg. But undoubtedly as a junior colleague, Peter was given a lot of guidance about how to proceed, and undoubtedly there were any number of constraints he was under and mandates he had to meet, and I'll talk a little bit about that. But there is no doubt that at this very early point in his career, Peter was embedded in the work of the committee and intimately familiar with all of its work. He drafted all but one of the chapters in the final report himself. And so what we know is that at this very early stage of his career, he was thinking deeply about the way that the legal academy is situated between the university and the legal profession. And it certainly doesn't seem to have done him any harm, I would say, to any listening junior academics. But the second thing I want to consider here, and really where my significant interests lies, is to consider this work, the work of the Long-Range Academic Planning Committee, in terms of the content and meaning of the report itself. And here I found myself surprised, because perhaps I shouldn't have been, but at how contemporary the concerns of this 1972 Long-Range Curriculum Committee are. It was indeed actually long range. That's not, the concerns aren't contemporary because the work failed to resolve the concerns, although I would agree with Professor Mossman, who says that the report is written in this consensus building style and doesn't make hard choices in terms of prioritizing what things law schools should do over other things. And I think that's a really important thing that you can see in this report, and I think you can see it in a lot of our contemporary efforts to think about what should a law school be and what should a law school do. Ultimately, the choice is between a law school which prioritizes training for the profession and a law school which prioritizes inquiry into law's fundamental logics, questions, and dilemmas, or perhaps I could just say between a law school which takes as its educational blueprint the work of the contemporary profession and a law school which asks more searchingly, what should lawyers do? Right, but the tensions that that require these choices are constant between, well, constant is the wrong word, but continue from 1972 to the contemporary moment. Regardless of what choice we make, even law schools that make those hard choices, they're not going to last for 40 years. So most schools with some diversity, the old way of using that word, in their faculty and student body will have to revisit these issues as background conditions shift and change, both in the profession and in the academy. So what I'm going to do is just give you a brief tour of kind of what this report was about, and then link it to issues which are very front and center challenges to law schools today. And then I'm going to close early so that we can have some time for questions, because otherwise I'm going to run out all the time. Okay, so this long-range curriculum committee was set up in 1972, and the context was this. I know for some of you this is not actually historical and you know all this already, but for me and for at least some people in the room, this is new information, so forgive me, this is just narrative portion. But the context was the relatively recent move of Osgoode Hall to York University, a move which, according to some, and I'm sure some may disagree, but was negotiated by a law society that was really under the gun in terms of the financial and space requirements that a more academic law school needed and simply could not be met down at Old Osgoode, as we sometimes call it. I don't know what this space is. I usually call it OPD, but I have heard it called downtown Osgoode as well. So ça change. But anyway, the move was not necessarily met with universal approval. And in 1971, the Law Society, having lost the last law school kind of directly under its eyes, set up a special committee called the McKinnon Committee to report on the length and content of the university programs and also the bar admission course and all matters relevant thereto. So the law schools in Ontario, hearing that the Law Society had set up such a committee, were obviously in a hurry to make submissions to this committee to illustrate the strength of their programs. And I think, as we'll see, to kind of push the Law Society away from this attempt at supervision. The model at that time was, at Osgoode at least, a model which includes the familiar upper 2 years of largely optional courses. And it also included the still current reality in which all of those many options might cover up the fact that the vast majority of law students still take many of the same large courses, including administrative law, tax law, business associations, and evidence. So in May of 1972, I've just added, so Peter just completed his doctorate, right? Just arrives at Osgoode. And I think they just gave more exciting work to young folks in those days, or maybe they just gave the worst work to young folks in those days, I'm not sure. But he arrives by 1972, he's being put in charge of this committee. Okay, so this committee was established for two reasons. One is kind of super pragmatic, which is they need to respond to the McKinnon report, which they know, this Law Society report, which they know is going to come out soon. So they need to have a response to that. But it's also set as its mandate was to report on, quote, the basic philosophy of legal education at Osgoode, the academic goals emanating from that policy, and suggested policies for their implementation. So that's all, just basic philosophy of legal education at Osgoode. We're still struggling with that. So the committee consisted of Peter Hogg as chair, Stanley Beck, a future dean who you may know passed away just before the mid-year break, David Weistab, who later moved to the University of Montreal, and Fred Siemens, professor and founding director of the Parkdale Community Legal Clinic. Harry Arthurs, our then dean, was ex officio, and two students were elected to the committee, including one of the very few women students at Osgoode at the time, Marion Irvine, who would write a report for the committee on women at Osgoode, subtitled Problems and Perceptions of a Growing Minority. So in the event, the committee had to prepare its response to the McKinnon report before anything else, before it could move on to kind of the broader work, which Professor Mossman suggests diverted the mandate. At least it diverted the mandate from that very broad basic philosophy of legal education at Osgoode into, already by page 2, describing its goal as more prosaically evaluating the Osgoode curriculum and formulating recommendations for change. So the committee did take its work really seriously, and it's perhaps a bit indicative of the different kind of faculty life of that era between 1973 and early 1974, that the committee met usually every week in open meetings. They held a well-attended symposium on legal education for students and faculty. They invited briefs from all students and faculty. They examined the curriculum of the McMaster Medical School. They went to the medical school to pay a visit. They had the student members prepare a number of really quite interesting research papers for the committee. They solicited faculty and student comment on those papers. They carefully studied the curriculum and methods of the Antioch Law School. I'm not sure how many of you are familiar with this super interesting institution in the US, which was described as the most ambitious attempt in North America to teach by clinical methods. And they surveyed the faculty on teaching methods and asked the faculty about suggested reforms, and then they got down to drafting. So this is a kind of ambitious and an obviously significant effort that involved research and reflection, led by the young Professor Hogg. I think this photo is contemporary, and it's a different kind of photo than you normally see of Peter, who's often kind of mugging for the camera or smiling or holding cake in his hand. And this one, I think, portrays that academic as a serious young man. And he'd only been appointed, as I said, in 1970. He became a landed immigrant in Canada in 1972, the same year that he started leading this committee, and he was only in his early 30s. And he was in the company of men who, though young, would come to be some of Osgoode's leaders and most respected scholars and educators in the 40 or so years to come. And yet, I think the report is not notable because of the decisions it takes. It largely declines to take any strong positions. And at least part of the reason for this and is mentioned in the report, and you can almost hear Peter's, I will not try to do the accent, but you can almost hear him kind of dryly and not without amusement saying, unfortunately it's cut off at the top there, but the committee turned out to be representative of differences of opinion in the Osgoode community at large, with the result that there was usually considerable argument over each issue. So I'm not going to delve too deeply into the committee's report here, but I will let you know that those of you who have been Osgoode students or faculty over the past 50 years have probably heard of several innovations introduced by this report, which became fixtures at Osgoode and still are. So clinical legal education was promoted in the report beyond the Parkdale program, with mention of the criminal justice clinical program, which we still have, and other forms of intensives which have continued to grow over the interim periods. The report introduced the perspective option. In fact, the first year curriculum that we have now, query how we think about this, is very, very similar to the one set out in the report, save of course that constitutional law, which I do teach, has gobbled up space, which used to be differently allotted, something we could think more about later. Just as an aside, I'm pretty sure if I issued a poll today asking the students to rate Peter Hogg's teaching, he would still get perfect marks. So the value of reputation is an actual thing. It was terrifying teaching at Osgoode in the early 2000s, teaching constitutional law and realizing almost everything was just not Hogg, not Hogg. Okay, so other things turn out to have come from that report as well. I'd always assumed, if you've kind of ever talked about curriculum at Osgoode, you might hear references to our upper year curriculum as a model in which we let 1,000 flowers bloom. And I'd always thought, well, that can't really be a misquote of Mao's 100 flowers, but because I came of age in the 1980s and I went to U of T law school, so I thought it's not possible that that's what's happening. But lo and behold, chapter 8 directly cites to Mao Zedong's 100 Flowers campaign and describing that optional curriculum, which was introduced in 1968. At the time, the report noted the hope that this would tap the creative energies and knowledge of the faculty. And this hope has been abundantly realized. So in 1968, they had 25 optional courses for those upper years. It had more than tripled to 82 in 1974, and there are now more than 100. But it is the optional and open nature of the upper year curriculum which so often seems to provoke concern from the law societies and professional regulators. Okay, so in some ways, this really, this report illustrates something really important about curriculum reform that I do wish I'd kind of realized, which is a lot of hard work and great ideas. Am I done? You're done. Yeah, implementing. Writing a report can't substitute for the hard work and great ideas and resources needed for implementation. So where I'd like to go with this paper is really to draw a connection between the Law Society of Upper Canada, as it then was in 1972, proposing to abolish articling and the various concerns it had in its desire to oversee law schools through a council on legal education, and what has been happening over the past decade in legal education through the auspices of the Federation of Canadian Law Societies and its efforts to create a national curriculum and to significantly define what it is that academic degree granting law schools need to be teaching in as curricular matters. The fact that we have this incredibly long period between these two significant moments, and that the context for both law schools and the legal profession has shifted so significantly between those moments, I think makes this a really interesting area to consider the dynamics of those relationships between the profession and the academy. And I think it has already been reflected in a number of different ways, but I think we could also think about the way that Peter's work reflects that tension. And in his own work, he did make those hard choices, I think. Whereas at the institutional level, those hard choices about what you're going to prioritize are much harder to make. Sorry.
Thank you so much, Professor Lawrence, for that really excellent ability to situate some very fundamental questions about legal education in a historical context and in a context that really centers the role that Professor Hogg played. I did promise some moments for questions. We are over time. I know lunch is waiting, but if anyone would like to address a question to any of the panel members, I think we can take a couple. Professor House, is that you?
That's me.
Oh.
So I thought I would briefly mention my unusual connection to Peter Hogg, which was as an intellectual and political adversary. I never studied with Professor Hogg. I actually learned Canadian constitutional law as an undergraduate from Peter Russell, who was himself a magnificent teacher. But in my early years as an academic at the University of Toronto, I was preoccupied with activism against the Charlottetown and Meech Lake Accords. And this is where I encountered Peter Hogg, who was, I think, a genuine supporter of Meech Lake and a half-hearted apologist for the Charlottetown Accord. And I just want to make a couple of observations. And one of the reasons I'm here is he was of my adversaries when we were fighting against Meech and Charlottetown, Deborah Coyne and I and a few others. He was probably the most intellectually honest and also, the nicest. He was unfailingly polite and friendly, despite the fact that I was a very young academic, attacking, as we've heard many times today, a kind of icon of the academy in his own turf, which was constitutional law. I just reflected on why Peter was taken in, and it seems to me that there were two features that, or two possible reasons I thought of. One is that I didn't get the impression that Peter really had been very much shaken or influenced by the major political crises in Canadian history. He seemed to operate his interpretation of the Constitution in a kind of abstraction from them, where politics was sort of like background noise. And I had a very different perspective. And so I think that was one of the fundamental differences between us. The other was, I think that he was a small c conservative in that he was very reluctant to go against the establishment consensus. And he really knew and admitted in in sotto voce that the Charlottetown Accord was a big pile of horse manure. But nevertheless, he would publicly defend it, and we would have to answer him. But of his and I think he wrestled with the fact that that as a scholar he understood its defectiveness, and yet he defended it. So those are some observations about Peter, who was one of the best intellectual adversaries I've had in a very long and very fortunate academic career.
Well, thank you very much for those reflections, Professor House. Very interesting to hear the firsthand experience of debating these questions with Peter. But with that, I think we do have to bring the session to an end, regrettably, and I do want to express on all our behalves a really warm thanks to all of our speakers who've done a wonderful job. Thank you.